on the rulings on this video and these matters. So your first argument is that you want to impeach the sergeant with the reckless driving conviction that he concluded his probationary sentence 2 years ago. Is that correct? Is that the length of time that you said, 2 years?
He was on probation for 2 years, but that period expired.
Would you want to be able to ask him whether or not, why don't you tell me rather than me telling you, so I can make sure I understand you.
Judge, I think the argument posited by Ms. Neal was that that we should be able to show that Sergeant Beltran has a tendency not to follow standing operating procedure of the Broward Sheriff's Office, and in doing so, while he was on duty on an extradition assignment, he picked up he was arrested for a DUI.
Okay, is there any evidence that during this incident or altercation with your client that the Sergeant Beltran was not following standard operating procedures?
I mean, besides myself testifying, Judge, I can tell you that he wasn't following SOP, allowing him to walk around continuously around the tables. When he's in the day room, he's supposed to be seated.
He was not allowed. Can you say that again, Mr. Lee?
When you're in the day room, you're supposed to be seated according to standard operating procedures.
All right, and what is the second argument you wanted to make, or second point of cross-examination?
Judge, during the pendency and preparing the litigation of this case, Sergeant Beltran appeared for deposition. He followed subpoenas as directed. He made sure that he was there on time, because if he didn't, he was under the threat of imprisonment by violating the conditions of his probation in Washington State.
Do you have any evidence that he had a pattern of not showing up when he was subpoenaed for deposition? So you want to be able to ask him if the only reason that he showed up is... And first of all, using prison for... Can you go to prison for reckless driving in Washington?
I said imprisonment, Judge.
Imprisonment.
Threat of imprisonment.
What's the maximum penalty for reckless driving?
I'm not sure what it is in Washington State, ma'am.
It might not even be jail time. You need to know that. You're going to ask him that, don't you? All right, what else? In the state of Washington, because I can tell you in the state of North Carolina and other states, those kind of things are very different. And some are not even considered a misdemeanor or felony or other.
Does that have the statute? It carries up to 364 days and a fine of not more than $5,000.
And what was the third area you were saying about the video?
Just that we don't have the remainder of the video as been previously litigated by motion to dismiss, because it was not preserved. So we don't know what happened just prior to this incident.
Your Honor, if I could just add a point, that the rule is that you can't ask a police officer if he's, or a witness, if he's see the case. That's not what the law is. That's what the defense wants it to be, but that's not what the law is.
May I step out and use the restroom real quick while
Sure.
you're doing that, please? Thank you.
opportunity to consider your arguments and refresh my memory on some of the rules of evidence and the specifics as noted in Professor Earhart's Florida Evidence Guide. And my rulings are as follows. The general rule, as you all are familiar with, is that a witness can be impeached with a prior conviction for a crime of dishonesty or false statement. And the only exception to that is when a person is called as a witness by the state and the person is either under investigation, under an open criminal prosecution, or the person is under supervision, such as probation, community control. And that is for the sole purpose of being able to show through that witness that the witness is trying to curry favor with the state because of the witness's current situation. In this situation, Sergeant Beltran was, I don't know if he was convicted or not, withholder, but I don't think it matters, because it would be admissible if he was on probation or if there was an active pending case against him. But the fact that he is no longer under supervision, the exception, the very limited exception that allows for questioning of an open investigation to show that the witness is currying favor, or perhaps currying favor, does not exist here. And so I don't believe the mere fact that he's a police officer makes it wide open for all of these other reasons. I think that the rules of evidence are clear that when a crime is not a conviction and or doesn't meet the standard for a crime, it is a conviction, but doesn't meet the standard for a crime of dishonesty or false statement, or it's not a felony, it's a very limited situation when you can bring it up. And I don't believe that that situation and those factual requirements are met here. So I am not going to allow you to cross-examine Sergeant Beltran on this reckless driving matter from the state of Washington. And that includes, your argument was that the bias, he was biased and that he appeared for depositions only because he was facing these charges in Washington. I agree with the state that the bias has to be a current bias. You can't question about a bias that happened at depositions several years ago. In addition, when it comes to any type of impeachment on this video, I have reviewed my prior order as well as my notes on the hearing. And the video preservation or lack thereof had nothing to do with this witness. It had to do with his superiors. So there is absolutely no relevance in asking this witness about video preservation, which was not part of his job responsibility, and he may not even know the answer to. He may, but I don't believe that that qualifies as impeachment material either. And finally, I had mentioned the possibility of just asking questions. If your contention is that this incident may have met the requirements of self-defense. However, after refreshing my memory as to the hearing in 18-14129, I found that there was absolutely no showing that the material on the pod video from the day showed any interaction between the sergeant and the defendant. That the video was not material, it was not exculpatory, and that that the pod video prior to, there's, I believe, 5 minutes prior to the incident and 2 minutes after the incident were preserved. But I did find previously that the pod video, any other pod video, would nevertheless be irrelevant to any claim of self-defense. If the defendant were to assert a claim of self-defense in this matter, any perceived threat on the defendant's part as it related to Sergeant Beltran would have to be imminent. And the pod video of the entire day would be irrelevant to that fact. in the moments leading up to the altercation were captured on video and represent the only time that would be relevant to a claim of self-defense because of the amount of time. So I don't know if your intention after he pled guilty is to try to assert a claim of self-defense.
I don't think the defense has mentioned that at all, Judge.
Well, you were mentioning the video, and I wasn't sure where you wanted to go with the video questioning. So I'm just bringing that up, that I have already determined that any pod video that is not available, number one, has nothing to do with this witness, and number two, would not be relevant to anything with self-defense. So with that, can we bring the jury back in and the witness in, please?